Good morning, good afternoon, good evening, wherever you're joining us from. Welcome. My name is Jess Peake, and I'm the Assistant Director of the Promise Institute for Human Rights. And I'm really delighted to welcome you to the inaugural event in our Global Digital Rights Challenges series, which is co-sponsored by the UCLA Institute for Technology, Law and Policy and the Promise Institute for Human Rights. On behalf of both institutes, I would like to acknowledge UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. Some of you might know the Promise Institute is the Center of Human Rights Education, Research, and Advocacy at UCLA, and we work to empower students with enriching teaching and experiential opportunities in human rights law, to engage with diverse frameworks and disciplines in generating new thinking on human rights, and advocating for change in coalition with academics, practitioners, and activists. We focus our work on 5 main thematic areas, including migration, race, the environment, accountability, and technology. The Institute for Technology, Law and Policy is a brand new research center at UCLA whose mission is to research and analyze to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. Together, we decided to convene this speaker series to address global digital rights challenges. As I'm sure everybody in our audience knows, around the world, repressive governments are seeking new and innovative ways to port censorship to the online space, while private sector tech companies are increasingly finding themselves responsible for making policy that impacts global speech. Here in the United States, digital technologies has also become the latest front for debates on systemic racism and the potential for new technologies to entrench patterns of discrimination. This series, which features global activists on the front lines of these debates, will examine the pressing digital rights challenges manifesting around the world. We will have 5 events every other Thursday until August 12th, and we really hope that you will join us for all of them. Today's event, though, is going to look at censorship and state repression of online speech. Our speaker for this session is Farieha Aziz, who is a journalist and co-founder of Bolo Bee, a Pakistan-based digital rights and civil liberty advocacy group. Farieha previously served as an alternate board member for the NGO constituency on behalf of Bolo Bee for the Global Network Initiative. She was an MS-FS practitioner in residence at Georgetown University for this past academic year, and in January of 2021, she was awarded the very first IA Rahman research grant by the Human Rights Commission of Pakistan to document the violations of fundamental rights under the Prevention of Electronic Crimes Act of 2016. This conversation with Farieha will be moderated by my new colleague, Michael Karanakolis, who is the inaugural executive director of the new UCLA Institute for Technology, Law and Policy. Michael is also an affiliated fellow with the Information Society Project at Yale Law School, where prior to joining us at UCLA, he led the Wikimedia Yale Law School initiative on intermediaries and information. Michael's scholarship revolves around the application of human rights standards to the online world, a pursuit which is informed by over a decade of experience in civil society, where he has worked on law reform projects related to freedom of expression, transparency, and digital rights, mostly in the context of emerging democracies. We're delighted to have Michael at UCLA, and we're so pleased that Farieha was able to join us. And Michael, I'll now turn things over to you.
Hi, thanks so much for that introduction. And it's great to be here. We're enormously fortunate to have Farieha here joining us for this first event. Just at the outset, I'll mention that we're going to be reserving some time at the end for Q&A. So if you want to enter any questions into the chat at any point, we will be watching for that. Or alternately, if folks want to raise their hand at any point to start a queue, we'd also be happy to have some direct participation, direct questions towards the end as well. Farieha, just by way of introduction to sort of open this up, I wonder if I could ask you to talk a little bit about the impact that the internet has had in Pakistan, particularly the impact that it's had on the political discourse and how expression in the country has changed as a result of internet access.
Thanks, Michael, and hello, everybody. So we've seen the internet in Pakistan change drastically, at least I would say over the last decade. in terms of how many people are using the internet, so I do remember, and back when website blocking became a problem, and that was 2010, it's about 11 years ago. And the attitude towards the internet and the policy-making circles, and even within the media or otherwise, was this is just an elitist platform for entertainment. And we've seen that change drastically, especially today, where for political discourse, and now I mean also mainstream political parties are heavily reliant on social media, because we're going through a period of heavy censorship within the mainstream. Television is muzzled, print is muzzled to quite a degree. And so social media is where they turn to the extent where the current day scenario is that the largest mainstream political party, which was in government previously, prior to 2018, and ironically, the government which introduced the Prevention of Electronic Crimes Act, the cybercrime law, which is now the weapon of choice for the current regime as well in the state beyond the government to crack down and muzzle dissent by way of criminal investigations and through regulatory power. He was charged, the prime minister who belonged to the previous party was charged with cyber terrorism under the cybercrime law. And so we've seen this sort of come full circle, and we've seen mainstream political parties not get, their speeches are not covered on television. And so they're turning to Zoom, and they're turning to online virtual conferences, etc. And Twitter has been, where Discourse is, which is why, obviously, and a lot of mainstream journalists, anchors who had primetime shows are no longer there. So now they've turned to YouTube. And so YouTube shows to see coverage of what's happening in the Supreme Court, what's happening in Parliament, what's happening politically, which we don't know about. This is where the discourse is now taking place.
Yeah, I've heard it said in a few different contexts that opposition parties, civil society, journalists had a bit of first mover advantage on the internet, where in a lot of parts of the world, governments, particularly more autocratic governments, didn't, they to a varying degree understood the economic potential of the internet for development and for commerce, and so encouraged it for that reason. And we're a little slow to wake up to the potential of the internet to actually empower different voices to speak, and potentially opposition movements to take root. And so, there was an early kind of flowering of opposition online and of speech online, followed in most countries by sort of a crackdown and an attempt to assert greater control over the online discourse. Does that reflect the experience in Pakistan as well?
It does. And so ironically, again, so the party now in power is the party that was in opposition when the cybercrime law was being debated. So they also opposed it at the time. The current prime minister called it a draconian piece of legislation. And today his government has been using this, and we've seen that how it's been used to silence dissidents, etc. Whether you say something about the government, whether you say something about other institutions like the military. So today is yesterday's government and today's opposition who actually brought ushered in this law is reliant and has also been charged. So we've seen this cycle, and so it's really, and this is something we've seen over decades, right? When you're in opposition, your politics are different, and when you're in government, the politics are different, and it's very easy for you to flip over. But the constituency most affected, obviously, are the human rights defenders and the journalists who, irrespective of who is in government, have faced silencing, because essentially in a democratic setup, you're not there to hold brief for the government or put in flattering news. And that's something we've seen the way that criminal cases have been lodged, frivolous complaints, third-party complainants saying, oh, the government has been defamed, right? Or an institution has been defamed on the basis of one tweet. And then you're pulled into the criminal justice system. So earlier, our concern used to be website blocking primarily. and that it's done in an arbitrary and discretionary manner. But that persists as a problem. But right now, the fact that people can be arrested or have been arrested or have to now go through the entire process, the process is used as punishment. That has sort of become our primary concern with the law. Yeah,
there's a saying that I've heard in the context of prosecutions here, which is that you can beat the rat, but you can't beat the ride. And so that I think speaks very well to this idea of process as punishment. Can we take a step back for a second, though, because you've mentioned a few different legal tools that the government has at their disposal. You've mentioned website blocking. You've mentioned the Prevention of Electronic Crimes Act. Can you take us through a little bit more detail? I guess maybe starting with website blocking, and tell us a little bit about how specifically those mechanisms have been employed, what the legal tool looks like, and how it's used to either crack down on voices that spread a message that is not what the current government wants to hear, or in order to sort of curate and manage the discourse in a direction that the government wants to maintain it.
So website blocking goes as far back as 2006, let's say, with Blogspot outage, right? And at that time, blogs were all the rage. And it was always non-transparent, and also you never knew who did it. Right now, so the Pakistan Telecommunications Authority, the PTA, has been given these powers via the cybercrime law. Prior to that, PTA was still exercising this function, but no law authorized them. So there was an assumption, because there existed a electronic media authority, even courts operated under the assumption that because there exists a telecommunications authority and they deal with telecom and the internet, therefore content management is also something that they should be doing. And so that's a challenge that we brought to court, the High Court in 2014, saying, well, they're going around blocking websites. There's no transparency. Nobody gets any notice. How we used to find out about a website being blocked is somebody couldn't access it. They'd post it on Twitter or social media. People would try using VPNs, and when they found out that they could access it via VPN, or somebody outside of Pakistan could access it but not here, then we'd figure, okay, it's being blocked. There was never any official confirmation. But then, then this followed in terms of there was political blocking. There was also, the pretext was always, so two things, that there's blasphemous content online and pornographic content online, and that's why we need to do this. And so, and then obviously during 2014, etc., we saw a lot of terrorist attacks, etc. So then there's a lot of hate speech, terrorist content, and so we also need to curb that. And so those sort of became the narrative tools to drive and gain legitimacy for these powers, even though by law there was nothing. And so when the challenge was before, our challenge was before the High Court in 2015, the government comes up with a cybercrime law. And what they decide to do is empower the Telecommunications Authority through the law. Now, how they've been empowered, it has been the subject of debate and challenges as well, because what essentially happened is that our freedom of expression article from the Constitution, which is Article 19, was copy-pasted as is. And the exceptions, and there are a lot of exceptions, so Article 19, the way it exists, is also problematic. But it's been outsourced to a telecom authority, essentially what are parliamentary and judicial functions, for them to decide what falls within the exceptions to speech. And so this is the manner in which that PTA has been exercising this authority is still overbroad, and it's still discretionary. No notice, no opportunity of hearing, and then they go and enact rules under this section, which exceeds the parent law as well. And so they amass powers to issue fines to social media platforms, to dictate to social media platforms and give ultimatums that that they should have their guidelines and rules in tandem with certain cultural, religious, moral, ethical things that are completely vague and subjective. And if they don't, then they'll block the platforms. And we've seen in recent years that this has happened. So we've seen PUBG and TikTok and lots of other applications and websites have been blocked. They've been the subject of challenges also. But this is something that persists. And despite high court challenges, you get one website restored, and then there's another direction for another one.
So there's three elements to the abusive nature of the process that you've mentioned there that I want to flag. One is the lack of, each of which in itself is a severe problem from a human rights perspective. So on the one hand, you mentioned the lack of transparency and the lack of public understanding of the rules, both as they're understood by the government and as they're, both in terms of the way that they're crafted, because they're crafted in a vague and open-ended way, and in terms of their application. Right, so you don't know who's making the decision. You don't know how the decision is being made. There's a lack of understanding of what's going on, which is easier to create, which is problematic insofar as it creates a gray zone around the line between permissible and impermissible speech. So that in itself is hugely problematic. But you've also mentioned this lack of public oversight. So a specific lack of public input into the process and a specific lack of due process itself. And the idea that this process is discretionary and that it's in the hands of sort of bureaucrats that are not really meaningfully answerable to the public as well. So I think all three of those are enormously problematic. All three of those are common elements to repressive systems of content regulation at the state level. And it is worth sort of pulling each of those out. The other thing that I wanted to sort of dig a little bit deeper into in terms of how these laws impact folks is, the way that I understand it from what you've said, you can essentially divide the abusive content restrictions into two different categories. On the one hand, you have content restrictions on the basis of morality, whether it's targeting speech because it is claimed to be blasphemous or is counter to a particular conservative interpretation of particular religious morals or what have you. And then the second category would be the sort of opposition political speech, which is targeted, and again, maybe it's not necessarily a bright line, because I know that opposition folks and journalists can be targeted on, accused of blasphemy and accused of moral offenses in what they've said. But the justification on that side seems to be a little bit different as well, insofar as you hear a lot of references to hate speech, to defamation of the state or defamation of public figures, to national security, because disclosure of ways in which the military might be wasting money could be turned back and said, this information is harmful to our national security. Does that framework conform to your understanding, or are there other areas where the speech is cracked down, and does that track to the reality of the experience?
It does, for sure. And so the website blocking part of it, definitely more cultural, and then it's about blasphemy or political speech and hate speech. So everything really. But the criminal investigations and cases, those primarily have to do with political speech, with dissent. And that becomes far more egregious because, okay, website blocking is problematic because there can be business concerns and other freedom of expression and right to information concerns. Here, what happens is that so the lack of transparency that we witnessed and the lack of due process that we witnessed with the telecom regulator vis-a-vis website blocking is what we're seeing with the Federal Investigation Agency. Now, this is an investigation agency that's sending out summons to journalists and to dissidents and to citizens. And they're also filing criminal cases on the basis of which that they're arresting people. And sometimes the basis can be a tweet. And despite how vaguely worded PICA is, the law is, even then there are certain categories. So for instance, hate speech. has to be either on sectarian or religious grounds, for instance. There are 3 categories. Now, obviously, political speech does not, if you're talking about a military officer or the prime minister or somebody in government, that does not fall within the hate speech category or the cyber terrorism category, or even what we refer to as the criminal defamation section in this law, which is again broad, which says harm to reputation, but the harm to reputation of an individual. It has to be an aggrieved party filing the complaint. What we're seeing a pattern is third-party complainants, an aggrieved citizen who says, I watched this on television, read this on Twitter or social media, and I felt enraged because an officer, a government institution, an intelligence agency has been defamed. And so here comes the complaint. Sometimes that turns into a first information report on the basis of which cognizable sections of the law are added. And so then begins this process to arrest. Or there's a summon. So and both are coercive processes, because the summons that have been received by various journalists are undated. They don't include a copy of the complaint. When people have written and responded and gone through their lawyers asking for a copy of the complaint, a second summon has been issued, and then a third. They want your presence at their office, and once you're at their office, then it's a very intimidatory environment. Sometimes, even though the law says that you cannot take devices without a warrant, they try and take your devices. The devices have been taken. They've been accessed at offices. So while all of this has happened, it's not just what we've seen is that there's a political backlash, but there's also a gender dimension, because as a result of call-outs, post-Me Too, sexual harassment, sexual violence, the same pattern has persisted. The investigation agency has summoned these women or people supporting these women on behalf of when men who've been named have they've filed complaints. And so there's a discrepancy between how their complaints are processed versus women who file complaints with the agency of harassment. So there's a complete, and we can say, and if we look at how malicious prosecutions are, this fits the pattern. There are malicious prosecutions where political speech is concerned, and even courts. So what happens is you get sucked into the process. If you received a summon, or if there's an FIR against you, that means now you have to go get bail. Now you're an accused under the law. The accused has to turn up at every single hearing. Sometimes, it's pre-arrest bail that you're granted. All the while you're anxious whether it'll be confirmed or not. They can move a bail cancellation application, whether it goes to trial or not. Those things are delayed. Do you file a quashment? Some people are able to get these quashed, others are not. And so it's expense, financial, emotional, psychological. There's time away from your job. People have been sacked because this is coming from influential political quarters. You don't want to be associated with somebody because they become a liability. So they turn into a liability. Their economic prospects, their career prospects, socially they're alienated. So there's a whole pattern of abuse, and this has happened specifically with several journalists over the last few years, with political dissidents from grassroots movements. And this is still persisting.
Yeah, I'm glad that you raised the gender dimension as well, in terms of how this is impacted and how this has been brought to bear against complainants about sexual assault or sexual harassment. Likewise, journalists who might report on these stories. I think that it is also an important aspect not to be missed, insofar as it's easy to view these kinds of laws as being put in place to defend the government, where I think that the way that you frame it is really useful to remembering that it's less about defending the government and more about defending institutional power structures, and that ultimately there are people that have the power and the connections and the resources to turn the system against you, against a person who they perceive as their opponent, as their enemy. And as long as there are people that are in that position, then these abusive aspects of the system become far more dangerous. Even if the law itself, and we've talked about, we can talk about specific, problems with the provisions of the law, that the definition of criminal defamation, the fact that there's a criminal defamation itself is problematic, or the fact that there aren't proper defenses to the way the defamation law is framed, the structure of the morality laws, the fact that a blasphemy law exists, all of these things are sort of in and of themselves problematic. But even if you corrected those problems with the law, the fact that the process itself is structurally able to be targeted the way that it does, is itself enough to significantly chill freedom of expression and to place a great burden on anyone whose narrative or whose voice is counter to what those power structures would want voiced and would want the dialogue, the discourse to contain.
It absolutely has, whether it's political speech. So we've also seen people retract, apologize, because how much can you invest in this process over one tweet? And they've seen how journalists and others have been pulled through months, sometimes a year, more than years before courts, before it actually goes away. And there's a perception that it only goes away when they're done with you. And and if they've managed to, let's say, silence you to an extent, right? Or they've caused the damage and they've, made you an example for others. And that's essentially what's happening, harassment through this. So whether it's a journalist and a dissident talking about politics, whether it's a woman talking about sexual harassment or violence, or even journalists who've covered this, like you said, even they've been summoned for their journalistic work, even people who use the word alleged along with, let's say, a sexual harasser, which does not, by any definition, fall within the ambit of this. Or even they've been summoned, and criminal cases have been registered. And then also we've seen, and you've rightly said that this is about institutional power, wherever power lies, and if power lies with large corporates, with influential people with money, with those in government, with those part of the state machinery. Across the spectrum. And so we've also seen cases where, the city I live in, which is in southern part of the country, so there was an oil spill some time ago. And so this company called Climate X, and they do environmental work. They linked it to a particular petroleum company. The petroleum company filed a defamation complaint against them. The Federal Investigation Agency went, raided their offices, took their devices. That company doesn't exist anymore after the level of escalation that they saw. So a lot of people this has had a chilling effect. We've also seen retractions and apologies, because this has also been used as a leveraging tool to silence, to change the narrative, to essentially, because what's also happening is on the side, so where these cases are taking place, there is a narrative on social media, and there's a social media capture now that we hadn't. 5 years ago it might have been different, 8 years ago it might have been different. So now the same people who have the power and influence to file these cases also have a PR wing that is then extracting outcomes and using it for certain narrative development, whether it's a state or whether it's powerful individuals saying, oh, see, they were lying to begin with, they're not credible people, etc. And so that's something that's happening, and we're seeing targeted campaigns towards journalists, towards women, towards the weaponization of blasphemy allegations. And that's the new frontier over the last few years against dissidents. While political speech gets called out, blasphemy becomes an immediate target on the back. And so once you start falsely accusing people of committing blasphemy, when you know it's really for their politics, because why are the women's marchers being targeted? Because they're also raising political issues like missing persons and enforced disappearances. And so this year we've seen a convergence, and this year we've seen the blasphemy allegations, false allegations being weaponized against the women marchers and the women movement after this year's march.
Yeah, the evolution in mechanisms of control is really interesting to think about, where, early on, the threat was to throw you in jail. And of course, when you throw someone in jail, there are all kinds of potential consequences about it. It makes a lot of headlines. You might get called to task by certain international bodies. It turns the person into a martyr. So now, rather than the step beyond that in terms of throwing people in jail is to punish you with the process. So we don't have to arrest you, but we'll drag you through the courts for years and years and years until just to hammer it into people's heads that it's much easier not to go against the people in power. And then the step beyond that is to weaponize sort of social media networks, create legions of bot accounts, online harassment. And that's sort of the step beyond that, is to, again, just make life difficult for people that are spreading a message which is inconvenient or disliked, just to make it a more difficult option for people, and to send a message that, the people that push in that direction are going to have trouble in their lives, and it's easier just to go along with the way things are.
Certainly, and that message has been received, because a lot of people I've been speaking to who are facing cases are saying, a lot of people say, why bother? Why did you say that? Just retract, just make it go away, because nobody believes that you should fight the fight, given what it is. And they don't see this as a fight to be fought. And also what you mentioned about the process, because on the face of it, we have constitutional courts, we have due process, we have a constitution, but none of the procedural safeguards are available. And that's the dilemma and crisis, where it's so easy to flout procedure, it's so easy to drag somebody, and then also say, well, it was really an outcome, it was a judicial outcome, what can we do? Now it's up to the courts to decide, right? And that then, in terms of the public narrative around it, where, for the longest time, and it's unfortunate, because we've had over a period of time this issue of enforced disappearances and missing persons. And in 2017, we saw this 4 to 5 bloggers just went missing. And a lot of people tend to respond with, if somebody's committed a crime, or if you have a problem with them, then charge them under the law or take them to court. Except when you say that, it's not equal. It's not on equal footing in terms of these cases and how the resources to fight them and how you're taken to court as well. So this is something I also now caution against, because this is not a level playing field. And the tools at the disposal of the state and other more powerful parties and pulling people through courts is another ordeal, to the extent where a lot of people who've been implicated in these cases wonder, and it's horrible to put it this way, is it better to maybe disappear for a day and then come back rather than be dragged through for a year, etc.? And this is what some journalists I've spoken to have said, is it just better to be punched a few times, but then not have to go through this entire thing? Because what we're witnessing right now is a whole range of people going missing, physical attacks, jail, arrests, criminal prosecutions, other kind of threats and intimidation. And so obviously, not to create a hierarchy of what is most abusive, all of it is abusive and it takes a toll on the person going through it, and also around the person's family and friends and work life, and everything is affected.
And I guess, when you talk about the, that's sort of one of the other things about locking somebody up, is when you lock somebody up, typically you have to give them a release date. So if a journalist is convicted of defamation and is arrested and is jailed for a year, well, that person's not going to be around for the next year to criticize you, but in a year that person's going to be out and is presumably going to go back to work. It is going to be an inconvenience again. Whereas these processes, from an autocrat's or from a repressive government's perspective, the fact that it is so endless and the fact that it can just drag on essentially indefinitely, allows them to be weaponized in a way that in some ways is worse than traditional repression.
And that's the other thing about convictions, and this is also a discussion that we've been having. So it's not even necessarily about convictions. It's usually people, the measure for a law, how bad a law is or how repressive it is about, okay, so how many convictions under it, let's say of journalists or dissidents, right? They're not even pursuing cases to take it to conviction because you'd have to put an effort into prosecution. They don't care about that. It's really the pre-trial stage where you see the maximum amount of coercion, where you have the least amount of remedies and procedural safeguards, even though there should be far more. Because the attitude of even courts, I've seen it before for some cases is, for instance, Article 10A was brought up, which is our due process clause, and the lower court magistrate seemed to be of the opinion that these rights will kick in once the trial commences. But what about pre-trial? If the investigation is not fair, their entire process is not fair, how will you move towards a fair trial? What about opportunity of hearing when they file applications for search and seizure permissions or arrest permissions? The accuser is not notified. You have no idea of the escalation unless you're keeping tabs yourself. So, basic procedural remedies and safeguards are not available to you. The law says you require a warrant, but they act without warrants. You challenge these things in courts, and the maximum relief you get is a summon is going to be suspended or the case will go away, but there's been no accountability that's followed. There's been no deterrence that if you've done this in one case, the investigation agency, or even for that matter, the regulator, is not going to repeat the same actions. So we've got cases upon cases going to courts. This same actions are repeated. There are high court orders saying you must provide notice, you must do this, you must do that, and still no copies of complaint are sent. So the impunity with which that they are acting, and it also shows a failure or a breakdown of rule of law in general, where Parliament has not extended the oversight it should have. Our courts have not, and this is also something that we're having a discussion about, is that the Constitution cannot be something that the High Courts or the Supreme Court deals with. It starts right with the magistrate, the Sessions Court, or the lower courts, because that is where you need your procedural safeguards the most.
The nexus with sort of the meat and potatoes criminal procedure issues, or the procedural questions, are an important thing to note. I want to sort of pull us back a little bit to the specifics around how these regulations manifest and the specific way that online speech is regulated, and maybe with specific reference back to the nexus between abusive laws that get passed in Pakistan and get passed elsewhere, and the regulatory debates that take place among more progressive democracies. I think that one of the things that you've mentioned is that the process underlying the law is so important, and what that can mean is that an identical law that gets passed in the United States and in Canada and in Pakistan can be perfectly fine in the Canadian and the American context, because there are those independent structures holding it up. But when applied word for word in the same way in Pakistan, it can have very different consequences because of the lack of independence of judicial or prosecution authorities, what have you. Can I ask you specifically about the way that regulatory debates among other democracies can sort of ripple the legislative, can ripple over to the legislative process in Pakistan? I think NetzDG in Germany is a natural starting point, but I imagine one could say the same thing about the Section 230 debates here in the US as well.
No, absolutely. And so while the law may look okay on paper, the fact is that in practice, due to all of these concerns in terms of institutional capture, etc., it plays out very, very differently. And what you also have to look at, and this is something I've been saying since the time this law was being debated, is look at the rule of law regime and look at the other protections that exist in these countries where that you reference, or the government and successive governments over time have referenced various laws, right? Whether it's UK anti-terrorism laws, for instance, or the Ofcom model, or even for, these are the kind of things. So my questions have always been, so do people also disappear, or are they denied due process, opportunity of hearings, etc.? Is it that opaque, non-transparent? All of these things matter. So for instance, regulatory powers and debates where PTA's powers have been justified by saying, and usually there are blanket statements saying, well, regulation exists everywhere in the world, we're sure, but so if we're talking about the US, for instance, but so does the First Amendment. Article 19 doesn't compare at all. One, because of the way it's framed. Two, in terms of look at jurisprudentially, what we have by way of case law and how strong that is, and look at the First Amendment and how it's been interpreted and applied, and also the kind of ownership and investment there is into defending this right in society at large, but also state structures. Right? And often we're told, well, don't talk about the US because it's not comparable. Okay, then you look at Europe, for instance, right? Or other countries, and you've mentioned NetDG. Now, we say, okay, fine, you're looking at this, but what you're missing out is the privacy protections of how certain things, so the EU as a model for privacy protections, the covenants, and what the UK's, what was it, the Investigation Powers Act was struck down by a UK court. And those are also sort of the examples that we cited, that, look, but this also happens. So show us examples where our courts have done something similar, or that we have these kinds of protections. So the way that it plays out, and even with the rules, so one, you give overbroad powers to the Telecommunications Authority, then you bring in rules with even more repressive things. And then PTA came out with a paper referencing different countries, that regulation takes place here and then the other. But we said, what is the process? Are they independent? Is Ofcom operate under the influence of the government? Or is it completely independent, right? And what does that independence mean? And over here in PTA's context, we've also argued, one, in terms of expertise. Essentially, you have civil engineers who make it as members of the telecom authority. How are they capable of interpreting and applying Article 19 provisions? Other than the fact that we find it completely illegal and unconstitutional, the parliament has sort of outsourced judicial and parliamentary functions. But even from a common sense perspective, in terms of expertise perspective, how are they competent to do that? And then in the manner that they exercise the judgments. And again, in terms of independence, if in your constituting act, the ministry can give you directions. How are you independent of the government? Even if you say on paper, you're a statutory authority that is independent. Then look at the regime around you. If you're going to pick up phone calls from influential quarters and send out notices to people, that is not independence. So, all of these factors that influence the regulatory regime. And so one is this populist sort of moral, cultural, religious side, where a number of complainants are going to file complaints. So even one influential person in the media who has column space and takes on government authorities because certain blasphemous content has not been removed, and that's something that they will take up. Or then they will block other kinds of websites and political at the behest of influential quarters. And we see these problems and we ask them, where else does it happen? You're talking about regulation, but there are notice and takedown systems as well, right? So give us comparable examples and tell us on paper and in practice, when you talk to us about a NetDG or even Section 230 now, intermediary liability, and this has been sort of the conversation of this last several years, since YouTube was blocked for 3 years in Pakistan, where the narrative has been, we have to bring these companies and have to convince them to localize, set up local offices, bring their servers. That way, the sense was we'll be able to exert greater content control. We'll be able to access information that we want readily, which we don't get right now. So this misconceived sort of notion, but it's always been driven by control. How can we assert maximum control over content? right? And that hasn't happened. And so they said, okay, let's give them liability protection in a limited manner. They brought it in the form of Section 38 in the cybercrime law, but then took it back through the rules, like negating it, saying, well, we're going to impose fines if you don't listen to us, right? And so this also mindset has persisted, and they're very keen. And often you see, even at the parliamentary level, you will have these off-the-cuff remarks, even at the Supreme Court level. Ban it if they don't listen, ban the platform if they don't listen, just rhetoric, off-the-cuff, which is damaging when in a day and age you're talking about e-commerce and digital Pakistan, and a Supreme Court judge in a completely unrelated bail hearing can make remarks saying, well, why don't you ban YouTube, because there's all this content available about us and the telecom authority is not doing anything. So in a nutshell, I mean, this adds to regulatory uncertainty in Pakistan.
Yeah, and I think it is worth emphasizing the difficult situation that the platforms are in and operating in these markets. And I have argued that this challenge and this problem is of their own making, because they charged into these markets without doing a human rights impact assessment at the outset. They just wanted the market share. They wanted to be the first ones in there to grab up as many users as possible, and they didn't do the proper process early on to sort of brainstorm about what they were going to do when faced with these kinds of challenges. But the threats of blocking, the threats of these big fines, the threats even to the life and limb of the employees of these platforms, that's not rhetoric. There are a lot of governments around the world that are deadly serious about this stuff. And it does put the platforms in a very difficult situation when they're asked to be complicit in abusive policies. But I want to step back briefly, because you mentioned the Pakistan Telecommunications Authority. I hope I'm getting the acronym correct. But you mentioned them specifically referring to parallel legislation in the UK, in Western democracies, in their sort of reporting on regulatory structures, and the government, I think, doing the same thing, where there's a specific move to point to a particular law like NetsDG or like the UK online harms bill, and say, look, this is absolutely not repressive that we're doing this. Look at all these wonderful democracies over there. They're passing the exact same laws, and that, to a certain degree, these processes in progressive democracies are providing a lot of cover. And I think that this is something that's true not just in Pakistan, but this is true among a lot of emerging democracies or fragile democracies, where legislative processes that are taking place within the EU or within Canada or the US, and maybe solely focused on their domestic impacts, are also ignoring the international impacts of what they're doing in providing cover for repressive rules to be written elsewhere.
No, absolutely. And so when the executive order was passed and the entire Section 230 debate, that's something that we were watching very closely, because it tied in with how can we hold platforms liable? And that's something that they wanted to do. So here you see cover, and the way that it's sort of spun and fed to us is, oh, look, the world's largest democracy is also having these debates, and the government is also coming up with these proposals, right? Or if, and UK is more compatible in terms of common law, so we derive a lot. Our penal code is based on, British law, etc. So those kind of parallels they tend to pick up a lot. But then Brazil is something, and so that's not a model necessarily what Bolsonaro is doing, but the fake news catchphrase, that rhetoric has been popularized so much over here. And so this is also something that during the previous administration and what's happening elsewhere in the world has had that impact over here, because for the last few years, ministers and government have been saying there's a lot of fake news. And essentially they were doing the same thing, where anybody critical of the government was a fake news peddler. Right? There was no distinction between disinformation and misinformation and legitimate harm to, let's say, citizens, and what could be some of the approaches to addressing the issue. It was always, okay, well, look, this is happening around the world and everybody is talking about legislating and curbing such this menace, etc. And look what happened in India with hate speech and WhatsApp, etc. and all of that. And even when we talk about India, and obviously a lot has happened over the last few years, right? When we started out debating this law, what was fairly recent was the Supreme Court striking down 66A. And that's an example we used to present. And we say, but this also happens. So you also have to look at what governments are doing and then how citizens are responding to that and the challenges being filed before courts and what courts are holding, right? It can't just be what, you can't just feed us what regulatory action the government at that time is doing, because more often than not, and this is not about which government, whether you're the global north or global south or wherever in the world, typically states and governments tend to be self-serving. It's about, preserving a certain kind of power or exerting something. So it's not necessarily, and we've seen this myth of larger democracies crumble. The only good thing, and this is what we say, is the safeguards, the institutions that you've invested in over a period of years and how they can hold forth. That's essentially.
Yeah, I'm glad that you brought up that, and also I think that we're in strong agreement about the damage that the whole fake news, fake news for the entirety of my life has been used as cover by autocratic, as a cover term by autocratic governments to refer to reporting that they don't like. So the whole explosion of this term in the aftermath of 2016 was, I think, hugely damaging in terms of its global impacts. And likewise, when you hear debates around Section 230, or these in the U.S. Senate, particular politicians sort of ranting and raving about how these platforms are out of control and need to be brought to heel, and like that's not, and a lot of the times that rhetoric here in the U.S. gets dismissed because they say, well, they're just bloviating and they're playing to their base, because the First Amendment really limits what they could actually do on the content side. But people in Pakistan, people around the world hear that, and it's a message that really resonates among governments that don't have those kinds of constraints. And that's not to say that you shouldn't take a careful and close look and at what the platforms do and be critical of them, and Lord knows, and I think both Farieha and I are not in any way have been strong critics of the platforms ourselves, but it's important for that criticism to be narrow and targeted and towards actual things, because the rhetoric actually can be damaging the way that it impacts legislative processes around the world. I was meant to take a break at 1:45 to open it up and see if folks had any questions. I am late on that, but I will do so now and ask if anyone in the audience is interested in asking a question either in the chat or wants to raise their hand and start a queue. They would be very welcome to join in the discussion. While we wait for that, I do want to ask as well, this has maybe not been the most optimistic conversation that we've had in terms of the challenges that we face. What are some avenues that people have been using to push back against these kinds of restrictions? And then I see we have a hand up, so we'll go to them after you respond.
I think the good thing, at least, has been that we've seen a lot more challenges being filed proactively. Summons being challenged, PTA action being challenged. Just today, there's a convention of the Supreme Court Bar Association, press organizations, groups, and they've also referenced the Prevention of Electronic Crimes Act as a draconian law and something that is muzzling media freedom, and it was something on the independence of the judiciary and media. So I'm glad that finally, 5 years later, after this law. It's sort of on the map. This is draconian, it's repressive. And so while we're talking about democracy and media freedom and judicial independence, PICA is right there on the map now as for on a broader civil society agenda.
So AD, do you want to ask a question? I'm not sure if you can unmute yourself. Can you? Yes. Yes.
So thank you very much for your incisive analysis. This is really a fantastic series. I wondered if you could clarify the example mentioned about the oil spill. I was wondering, it seemed that the organization was the one that had the office raided and the devices confiscated. And I wondered what had happened to the individuals involved subsequently. And it made me also worry about your safety, what steps you take to, you know, you're such a powerful advocate, Ms. Aziz, in your work. But my main question was really in Pakistan, how these debates about censorship affect visual culture. To what extent do these kinds of repression affect the dissemination of images, art, memes? And I wondered if you could just discuss how this kind of analysis applies to images of that kind. Thank you.
Thank you for the concerns. Let me begin with, so the petroleum company case, actually, the level of escalation and coercion after the raids and taking of devices, and obviously there was outside pressure that from what I know and heard, the company just wrapped up. Those individuals are not here anymore. And that was the level of influence and what happened as a result of the pressure of this case, but also beyond the pressure of the case, like outside what transpired. In terms of safety, it's always a concern. Obviously, you don't know, and this is something that's a refrain amongst journalists and dissidents, is you don't know what the red lines are anymore. They constantly keep shifting. At least personally, what we had decided, and there's also been a systemic sort of crackdown against CSOs and NGOs. I mean, labeling has been there for several years now, foreign funded, Western agents, this, that, and the other. But we've seen cases of terrorist financing, trumped up cases being registered against dissidents who run organizations, or just they're not getting regulatory screening, they don't pass that, so they can't keep their organizations functional, or they've been asked to close down. So we've seen all of that as well. As far as my organization is concerned, so we also thought that a lot of things we would do in a personal private capacity as well. At the moment, it runs as a non-funded, and we wanted to transition into a citizen-led, non-funded movement of sorts. We're still there on paper, but this is actually what, these are some of the mitigation steps. I mean, there are people who can't do this. There are people who need to keep on their employees in offices and pay them and etc. And it's becoming a very difficult space. We know that people are getting attacked. And so it's really about, I think, for us, the strength now is that there's conversation around it and there's resistance emerging, where you see civil society groups and press groups and bar associations, so the legal community sort of coming together, because it's now a crisis for everybody. And that, I think, you source support from that if something happens, then there's some people to turn to, which, you know, we've seen in the case of journalists, there's a journalist defense committee that's been set up by the Pakistan Bar Council. And so immediately when there are cases, they file representation. So at least that worry is not there. So we're working towards that. In terms of your last question about cultural impact or visible impact, so satire is also not taken or appreciated, or there's a lot of offense towards it. And so one of the first websites actually, which was blocked in Pakistan, was a political satirical website. Obviously, in terms of cartoons and defaming and morphed images, that was a concern which existed prior to the law. And we used to use examples saying, I remember I used to use this example from Turkey a lot, where this doctor apparently has shared a meme of Erdogan as Shrek, and he was being prosecuted for it. And I said, tomorrow, if this happens, yeah, this is most likely somebody's going to file a case. We haven't seen that landscape change so much per se in terms of the visuals of it, because as a country and as a people, we like our humor. Our humor is quite dark, given things that happen around us as one of our survival mechanisms. So we're big on memes and political humor and all of that. So WhatsApp forwards and images and etc. All of that is there. But obviously, there's a kind of backlash, not so much legal just yet, but certainly that's something that still keeps going. And we like our humor till, I guess, the first case over a meme emerges in that sense of our political cartoons, because again, there's been a sort of a history over here.
Yeah, I think it was the Pakistan cybercrime law that had a specific provision that made it illegal to digitally alter people's photos. This was back in 2014, and I remember even then seeing that provision. I think it actually is still in the law, but seeing that and thinking like that's not going to mesh well with internet culture. But yeah, it's illuminating to these you know, the disconnect between the vision of the internet that is often pushed forward or represented in this legislation and how people experience it. There can often be a very wide gulf between the two, and the criminalization of normal or innocuous online behaviors is a potent tool by governments who are looking to exert control over their critics. We are just at the top of the hour, so I think we will leave it there. Thank you so much, Farieha, for being with us for our first event in this series, which I very much enjoyed. And I think it was a very illuminating conversation. Our next event is on July 1st, when we will welcome Marwa Fatafta, who is the Middle East Policy Manager at Access Now, and who will discuss content moderation and the role of platforms in online speech. Please join me in thanking Farieha, and I hope you will also join us for our next session in a couple of weeks. Thank you, and goodbye.